Parul Institute of Law, Parul University. I warm welcome our eminent speaker, Mahalakshmi Pannavi ma'am, who is the senior designated advocate at the Supreme Court of India. Let me introduce, and the topic of this webinar is on the judicial activism, and this is the very interesting topic for all the students at Parul Institute of Law. Now I will just give a short description about ma'am. Mahalakshmi Pannavi madam is a senior advocate, is also the first lady from the Karnataka, and she is designated by the full bench of the Honorable Supreme Court of India. While she was attending the rent control proceeding and defending her mother case, little did she know that she would find her true calling in the law. She is also one of the renowned advocates at the Supreme Court of India, and she has achieved many milestones in her career. And she has also she has left no stone unturned in using her power to help the women, and she desires to use her expertise in uplifting the downtrodden women and making them aware of their legal rights. She is popularly recognized for her immense effort for bring the women related issues to the fore. So not going for the more description because name is himself is sufficient. So, ma'am, I warm welcome, and now I will tell Dr. Akhil Sayyed sir to warm welcome Mahalakshmi ma'am. Hello, Akhil Sayyed sir.
Thank you, Dr. Rajesh. Thank you very much for giving me this opportunity to welcome learned advocate Ms. Mahalakshmi Pavani ma'am. Ma'am, it's a great pleasure that you are here at our virtual platform. We would have been very much happy if you could have been with us on the occasion of celebration of Women's Day, International Women's Day. But that was God's wish that we could not celebrate International Women's Day together. However, I am very much thankful that you have kindly accepted our invitation, and at least you are with us on the virtual platform. At the same time, I request you and I invite you for your physical visit at the campus whenever the things get normal. Ma'am has actually chosen a very good topic. As Dr. Rajesh already mentioned, she is an icon for the women empowerment and always helping hand for women from every aspect of the society. But today what she is going to talk about is judicial activism is not only important for the students but also for the law teachers and the activists. That how judicial activism actually helps the activist people also. And nowadays there are lots of social issues which because of our social structure, now it goes to the judiciary, and now judiciary has to go beyond their boundary lines and transform the society. So today I am sure that her lecture is going to be very important and interesting also. So I'll not remain in between the speaker and the listener. So I once again thank you and welcome you at Parul University. Thank you, ma'am.
Good morning to all of you. I thank you, Dr. Akhil Sayyed, for having given me this platform to speak. Thank you for your kind invitation, Professor Rajesh Singh and Dr. Syed. Whenever the corona becomes better and when we are able to move around and in a safe environment, I'm sure I will be visiting your university. And it was unfortunate that I couldn't make it on Women's Day. So the topic today is judicial activism. So before we go into judicial activism, I would like to say that before judicial activism, there is separation of powers. So the Montesquieu principle of separation of powers, they elucidate that each wing of the state would operate in its own respective sphere, and it has with specific duties, obligations, and roles assigned to them. So in UK and the United Kingdoms, there was superiority of parliament, not the courts. So the parliament was considered to be supreme, and if I may add, infallible also. It was just not to follow the law of the parliament, but it was there to protect, respect, uphold, and never bypass or delegitimize the law made by parliament. In fact, the courts could not even strike down the legislation. But this view of this UK judiciary, the superiority of parliament, I must say, in Lord Latham, in a very unconventional way, in 1950, said, and I want to quote him on superiority of parliament. He says, Lord Latham was one of the first judges to adopt an unconventional view in Australian Communist Party versus Commonwealth. Please hear me, that it is sometimes said that legal questions before the High Court should be determined upon sociological grounds, political, social, or economic. I can understand courts being directed, as in Russia and Germany in recent years, to determine questions in accordance with the interests of a particular political party. There, the court is provided with a political standard, but such a proposition as that of the recent banking case should have been determined on political ground, and the court was wrong in adopting an attitude of detachment from all political considerations. Appears to me merely to ask the court to vote again upon an issue upon which Parliament had already voted, or could be asked to vote, and to determine whether the nationalization of banks would be a good thing or a bad thing for the community. So in the separation of powers in our Indian context, we categorically say that our laws emanate from the fountainhead of the Constitution. But even though there is no clear worded reference to principles of federalism, republicanism, separation of powers, or in the Constitution, except with a vague reference in Article 50 to separation of powers with the executive, nothing much has been said. But when you read the Constitutional Assembly debates, or the Constitution itself, which is very clearly drafted and very craftily worded thing, the concept of secularism and separation of powers, it categorically demarcates the roles played by the president, the prime minister, the members of parliament, the role of the judiciary. So ordinarily, these roles, they have to be strictly adhered to by performance of their duties, keeping in mind their boundaries and limitations. So they cannot transgress. In fact, the judiciary, it cannot transgress. But what happens when this kind of a thing happens? The judiciary steps in, it steps in to play a proactive role. Why? Because the legislator and executive both have simply failed the citizens of this country. So when they fail to discharge their duties, it is then the courts step in. So in my submission, I would not say it is judicial activism, but I will say judicial review. Why do I say judicial review? For the sole reason that here there are laws enacted by Parliament, but the same have not been implemented or could not be acted upon. So it is when the executive and the legislature fail, then it is then the Supreme Court or the high courts, they step in. They crack the whip and say, it is like a ringmaster. In fact, the courts, they haul up the legislature and executive and say that, look, if you all don't do this, this is a court order. You all have to step in. You all have to live up to the expectations of the people. So the Constitution, apart from saying that, we have Article 32, which is known as the heart and soul of our Constitution. So, and Ambedkar said it is the heart and soul of the Constitution. So when your fundamental rights are infringed, it is then any Indian citizen can knock the doors of this Supreme Court or the High Court under Article 226 and ask for justice. They can seek action, judicial action against inefficient state action. So that is the reason why I say it is judicial review. And this Indian system is from separation of powers. There is a judicial known as the judicial activism, which you all speak of. So it is one of checks and balances. So when a constitutional wrong of Parliament, it can be overturned by the Supreme Court and the superior courts. So this is basically to curb the menace of abuse of power and prevents institutional domination. So that is when the courts step in. And what exactly was judicial activism? It was coined in 1947 by an American historian and educator known as Arthur Schlesinger. So judicial activism was coined in 1947, but in India it came in the mid 70s. And judicial activism was a concept which turned into PIL, public interest litigation, and who were for so judicial activism for me it's a result of legislative inaction and executive inaction coupled with excessive inefficiency. So that again is judicial activism, and it is thus the consequence of legislative dereliction and executive apathy. So when the executive and the judiciary executive and the legislature, they fail, they are inefficient, they cannot implement their own laws which have been made, that is when the courts step in. And this concept was revitalized. It regained a lot of mileage in mid 70s. And there are the four founding people of Supreme Court: Justice V.R. Krishna Iyer, Justice P.N. Bhagavati, Justice O. Chinnappa Reddy, and D.A. Desai. So they gave a lot of importance to these PILs. So PIL in the sense is a public interest litigation in the form of judicial activism. So they showed the way into giving a lot of relief. They gave a lot of relief to the citizens of this country. Why? Because the executive has completely failed them, whether it is right to clean. See, we have fundamental rights. We have entitled to right to sleep. We have right to clean air, right to food, right to education. But all these rights are very, documented in the Constitution of India. But who actually delivers this? It is this courts that rose up to the occasion to deliver justice. And justice should not only be done, it should be seen to be done. So although there are a lot of criticism about these judges at the Supreme Court order and all that, I must say, but the Supreme Court is like a fruit-laden tree, no matter how many stones are hit on it, it always gives fruits. So that is how judicial activism has worked, because they keep in their mind that the paramount welfare of the citizens of the country, and they do everything in their reach to render justice. Sometimes what happens, they don't follow only the law. They rise up to the occasion. They take into account social, economic, political factors, legal factors, changing trends of the society. They take all that into account when they are rendering justice. So what is the ultimate objective of this judicial review? It is to bring in parity in society, to rule in favor of the less privileged, keeping in mind the established principles of law. So when I say the established principles of law, I may also say that Supreme Court, normally there is the rule, there is a limitation act. So if you and I file a litigation, and if they go by procedure, they say that this is the period of limitation, 90 days. But sometimes they condone the delay also if it's beyond 100 days or 200 days. But there are petitions, and I'm acquainted with it because I appear for the Legal Cells Authority of India, legal cell work, legal aid work, we say. So we do a lot of criminal matters. There, the Supreme Court puts aside this procedural irregularity. They close their eyes to this limitation. So why do they do that? They know that these people who have approached the legal aid are all very poor people. They are illiterate prisoners who are languishing in the jails of the country, and they do not have this possible reach to justice. Even accessing justice for them is a dream. It's a milestone. So there are a lot of prisoners who languish in jail without legal assistance or legal help. They are even oblivious to the fact that there exists a law which can reach up to them, which can give them justice. So Supreme Court goes all the way that to the extent that it condones delays of even 2,000 days or 3,000 days. Why? They do not follow the law, procedural law book of limitation laws and things like that. They go out of their way. Now what happens? When people are very poor, and they cannot approach the court. Some people, they are like-minded citizens, they are service-oriented citizens. They even write a letter to the Supreme Court or to the High Court. So it is an epistolary jurisdiction. So by letter, by way of letter petition also, the Supreme Court, the courts have risen to the occasions. They have gone, they have even where they cannot adjudicate just because they are technically handicapped, they appoint committees also. They appoint expert committees and they take their guidance when they are laying down a law. So if you see, it was in 97, like Delhi was choking with pollution and things like that. So they decided to phase out all diesel vehicles and all petrol vehicles from the streets of Delhi. So how did they do it? It didn't happen overnight. So they appointed a committee called the Burelal Committee. So they said that, look, you will give us a committee report, you will help us to think. So that man came back after 2 years also and said, no, the government has not bought a single bus, CNG bus. So it was then, they cracked the whip. They brought the executive on its knees and they said, no, we cannot ask the people of Delhi to stop breathing. Now, come on, get up. And, and that is how CNG was implemented. It came into force. And now we have cleaner air. In fact, as president of the Supreme Court Women Lawyers Association, we also moved a petition in the NGT for ban on transiting vehicles of trucks through Delhi. What happened was there was an order of 2003 December, and it categorically said it prevented vehicles, trucks, especially trucks and buses, to pass through Delhi. And that order was not implemented at all. So we women lawyers moved the NGT. So when we moved the NGT, the next day, it was in the newspapers that women lawyers have moved for clean air and a ban on transiting trucks. So it was then Supreme Court said, no, NGT cannot take a decision. We are superior, we are the Supreme Court, and it is within our jurisdiction. The matter was pending here. So I still remember Mr. Harish Salve, he was the amicus in that matter. So he said, my lords, the culprit is here who's moved the NGT. I said, my lords, it's not because I moved the NGT not for myself, not asking for clean air for ourselves, but for you and us. We all need to breathe clean air. After that, there was this petition by 3 small children, 2-year-old and a 3-year-old boy. And one happened to be, the lead petitioner happens to be my friend's son. So he was just a 2-year-old and he moved the petition seeking for ban on bursting crackers. He wanted clean air because he was an asthmatic child. So they said this cracker ban, they burst crackers during Diwali, which caused a lot of smog and pollution, made breathing very difficult because Diwali normally comes during the winters. So what happens? The air becomes very polluted. It's filled with toxic substances and smog, and it causes a lot of breathing problems. So that time, Arjun Gopal Shankar Narayan, a small child moved. So despite the fact that the Sivakasi, the cracker factories at Sivakasi, despite the labor factory was going into closure and things like that, but the court stood up, rose to the occasion, and they said, yes, maybe there are a few units that will be closed, but that doesn't mean that we should stop breathing. It is a matter of a fundamental right. So in fact, the Supreme Court, whatever said and done, even the high courts, whatever said and done, they are service oriented. That is why we call our profession a service profession, not a trade or any kind of a business. Why? Because there are millions of people who cannot even access justice, but there are a few activists or letters that reach the Supreme Court, and where the Supreme Court passes orders which gives a 180-degree turn, it gives a 360-degree turn, and it acts as a deterrent to the authorities to act fast and swiftly and not incur judicial wrath by way of contempt. So if contempt is going to be issued, then the authorities buckle down under pressure. See, apart from that, I would also like to say, nowadays people say that, the judiciary is overstepping its limits, it is crossing its limits, it is overarching, it is, it is overarching, dominating, activist kind. These are all very unfortunate utterances made by people. Why do they say that? They say that because Supreme Court, when it cracks its whip, it wants to ensure there is transparency and accountability. In the 1970s, whatever tenders were passed or arbitration awards were passed, they would not go into all that. Why? Because it was policy decisions. But now in the 90s and 2000, early the 20th century, 2000, they have started looking into tender orders. They are looking into these allocation of licenses. You have the spectrum scam, the 2G scam, the coal scam. So what it is, when the executive is hauled up, that is when they say that, look, the judiciary is overstepping its things. But when judiciary comes into its rescue of the executive, then they don't say anything. So asking for transparency or asking for guidelines to be laid down for who can contest election, whether if he's a convicted criminal, will he be, can he contest, for how many years he can't contest, that is when the heart burns of the executive. But when, there are situations when, like if you take the Mandal Commission, when the Mandal Commission report came, there was fire across the country. There was a lot of riots and things like that. But the Supreme Court put a full stop to that Mandal Commission by laying down the law in Indrasani. So that time the politicians, they accepted it very well because there was a quietus. Even when the Babri Masjid was demolished, the matter was pending, they accepted as the judgment of, as the law of the land, and they put a quietus, because even this Ayodhya judgment, when it came, it settled everything. There was no going back on anything. The politicians, whatever they had in their political agendas or manifestos, it was all given a quietus. Why? Because the law of the land had to be respected. It was the Supreme Court that raised to its great heights in putting a quietus. So when Supreme Court acts in matters of fundamental rights and education or things like that, their verdicts are happily accepted. But when it transgresses on their domain of appeasement politics or vote bank or bureaucratic lags, then they get a little disturbed. So that is not actually a right thing. So, and apart from that, I will also want to speak or say about Upendra Bakshi. Upendra Bakshi has just a minute. Yeah, Professor Upendra Bakshi, an academic genius, has virtually taught and trained almost all the top senior advocates and a bevy of Supreme Court judges, has noted in an article the qualities of an activist judge. What he says is quite pert and cannot be elucidated with any more clarity. He states, and I quote, "An activist judge comes into being when she chooses to conscientiously disregard the 5 commandments. The qualifier is important. The aspect of consciousness is concerned with the source of legitimation of judicial power. An activist judge does not always look to legitimation from the holders of executive powers or of economic power. She rather looks at social legitimation from the deprived, the disadvantaged, and the dispossessed groups of society. And that choice is critical. Once made, such judges remain activists during the moment of rule of law, as well as the reign of terror. And it is the articulation of these grounds of this conscientious choice which enables one to distinguish from judicial adventurism from authentic judicial activism." In fact, I also feel that the courts are very uncomfortable with the increasing divide, between the rich and the poor, and when the unimaginable opening up of the economy, and with yesterday's technology becoming redundant today, closing down of the courts. I mean, virtual courts happening. So, and the technology becomes irrelevant today, and they are constrained to bring about some semblance of equality or equity, and And the court actually is exasperated. Why? Because they don't want to, transgress into the executive and legislature's powers or domains. But what else can it do? It has to bring about quality, sustainable equity and equality. So they invoke their extraordinary jurisdiction to bring about economic equity amongst the poor. So even sometimes Supreme Court has also suo motu taken cognizance of atrocities happening across the country. So when they see the newspaper, like so many girls are being harassed in the home, for the women and child, they are being subjected to harassment and torture. Then they themselves have, taken cognizance, issued notice, and cracked the whip and said, what is happening? Why are these poor, unfortunate women or children being harassed? Why are they being subject to sexual brutality? So there are instances when the Supreme Court itself acts. And so that is how I look at it. In fact, there are a lot of case laws which I would like to refer to, and before I go in there, I would also want to say there are practical difficulties for judges in adjudicating PILs. So what are the practical difficulties for adjudicating PILs? Here again, I must quote Professor Upendra Bakshi himself. He has presented a typology of fears which are generated by judicial activism. He observes the fact entails invocation of a wide range of fears. The invocation is designed to bring into a nervous rationality amongst India's most conscientious justices. So when a judge decides, he also undergoes a lot of fear psychosis. There are so many kinds of apprehension in his mind when he sits there to dispense with justice. So what are the fears? He has in fact laid down the fears. They are ideological fears. They fear, what is ideological fear? Is when a judge feels, are they usurping the powers of the legislature, the executive, or the autonomous institutions of a society? So that is their first fear. Are they going to render justice, or are they transgressing into other domains? Then epistemic fears. Do they have enough knowledge about economic matters, or do they have enough knowledge about scientific matters? Then management matters. So are they doing justice by adding this kind of litigation workload to a situation of staggering growth of arrears? Why do they feel that? Because you see the strength, the sanction strength of the judiciary is 1,080. As of today, we have only 661 judges. So they feel by, opening or giving relief to somebody, they are opening the doors of the court to many more. So can they shoulder the burden of this staggering cases? Will they be able to deliver justice? Because judiciary has a lot of pitfalls. They don't have enough staff. They don't have enough judges there. So that is another fear. Then legitimation fears. Are they not causing depletion of their symbolic and instrumental authority by passing orders in judicial public interest litigation which the executive may bypass or ignore? Would not the people's faith in judiciary, a democratic recourse, be eroded? What are the democratic fears? It is a profusion of public interest litigation, nurturing democracy or depleting its potential for the futures. Biographic fears. What would be my place in national affairs after superannuation if I overdo this kind of litigation? So these are the fears the judges have to have in their minds. This is what Professor Upendra Bakshi has said, and that is why the reason why I quoted him. So, and apart from these things, I want to give a few examples. The right to life, how the Supreme Court has interfered. The right to life was given creative and expansive interpretations which have indeed formed the core of many subsequent litigations. So the first case is in Satwan Singh versus D. Ramaratnam APO, which was followed by Menaka Gandhi's case in the Constitution bench. The right to go abroad was recognized. Then Sunil Batra's case, right against solitary confinement of prisoners. Charles Shobraj, he was a prisoner, an international prisoner, international smuggler also, and he moved the Supreme Court. So it was against the fetters. So after that judgment, there were no fetters on any kind of A-class prisoners or the prisoners of his kind of terrorist kind of prisoners. Then we had in Prem Shankar Shukla's case, the right against handcuffing. Then Hoscott, legal aid, the right to legal aid, free assistance. Then we have Francis Corley Mullen. The every offending action to human dignity is deprivation of life under Article 21. Joginder Kumar versus State of UP. The right to legal representation during criminal investigation and the right to be informed on grounds of arrest and to be communicated the same to one family member of the arrestee. So this was very thing, because the police, the men in khaki are terrible monsters. In fact, who will police the police? There is an article, So these men would swoop on people and they would arrest them without giving them reasons of arrest and things like that. Then that was decided in Joginder Kumar. So it was mandatory as to spell out the reasons for arrest. Olga Tellis, right of livelihood. Municipality was injuncted from removing pavement dwellers. So even a pavement dweller had his right. He could sleep there. So nobody could, remove them. It was his fundamental right, because where can shelter be provided to all of them? The government has failed its citizens. Then there is this AG of India versus Lakshma Devi, where they said right against public hanging. Then Parmanandra Katra's case, which was followed by VP Shanta, where they said that the right to health and medical assistance as a fundamental right. Accident cases, when people are rushed to the hospital will call up the police. They will say it's a medico-legal case, it's a run and hit case, and the person who takes the victim there is hauled up. So, people were frightened. They said, "Arey, jane do, why the hell should we get into this? We will be dragged into unnecessary litigation and things like that." No, but Supreme Court laid down the law. They said if in an accident case, the victim has to be given first aid immediately, and there is no detaining the person who brings this kind of an road accident victim to the hospital. Aid has to be given. See, amongst there are a few activist lawyers in our profession who have made a huge change of differences in the life of people. So they are people like Indra Jai Singh. She's a great lady, a firebrand activist. I adore her. Then we have Kamini Jaiswal ma'am. She's also a firebrand. And we have Mr. Colin Gonsalves. We have Prashant Bhushan sir. In fact, Colin Gonsalves sir has been a party to so many, socio-economic reform cases where he's been instrumental in getting people, the poorest people, justice. That he's done this PUCL, that People Union for Civil Liberties case, wherein he ensured that 350 million tons of food was being given to people across the length and breadth of the country. There so many people came to profited from this judgment, the public distribution scheme, which was not even going to anyone. So the question there before the court was whether the stock of food grains lying in the warehouses of Food Corporation of India, is it when millions in the country go hungry, constitute a legal injury, and if yes, what can be done to remedify it? So that was the question, and they said that right to food is a justifiable, reviewable, expandable, legally enforceable constitutional right and inviolable. So then we have this right of the Jija Ghosh's judgment, so where the rights of disabled persons had to be recognized. So here in Jija Ghosh, she was a patient of cerebral palsy and a very well-known woman. So she had to go for a lecture to Goa, and they offloaded her in Calcutta. She was treated like a criminal. So then she moved the court, and the court held that the pilot and its crews were guilty of offloading her, and they made a payment of compensation of 10 lakhs. Why? So because it is, I would like to quote Joseph Shapiro. He said that non-disabled do not understand the disabled ones. So here there was a Disability Act, but not enforced. So it was in this judgment, the court had to rise to the occasion and say, look, here are people who are disabled, but they have every right. They cannot be treated like criminals. Then we have Nandini Sundar's case versus State of Chhattisgarh. Here, where the question was before the court whether the appointment of tribal youths as special police officers for counter-insurgency activities against Maoists and Naxalites constitutionally valid. The court said no. They are found to be violative of Article 14 and 21 of the Indian Constitution. But they stood for the rights of the tribal youth and stated that such risky employment could not be conceived under Article 21. So the court asserted to the state that its policy decision should be legal and be supported by the constitutional framework. So although they said that they cannot be appointed as special officers holding guns and things like that, but they still stood up for their welfare. So, and then you have the Naga people's movement of human rights versus Union of India. Here was a question whether the Armed Forces Act enacted by Parliament constitutionally valid or an exercise of colorable legislation. Here, there were about 1,530 people who were executed in the state of Manipur, just for the reason they were suspected to be terrorists. That Armed Forces Act, the armed forces people had that to shoot down anyone. So that was when these Naga people, human rights people, they moved the Supreme Court. And what did the court hold? The court upheld the constitutionality of the AFSPA, but gave certain cautions in the forms of do's and don'ts. And they said the do's and don'ts are a range of duties, such as a person should not be kept in custody for a period longer than required and should be handed over to the nearest police station. No force should be used on a person arrested except if he's trying to escape, and no third-degree methods, no methods which cause pain and suffering should be used against those arrested or under suspicion, or to extract information or confessions out of them. It is these methods. And these methods should not cause any pain and suffering, and should not be used against those arrested or under suspicion to extract information. Only the armed forces should arrest a person, and they should not carry out any form of interrogation. These are one of the many guidelines. So there, in fact, that under the thing of terrorist, they take a 12-year-old boy, they barge into his house, and they kill him in front of his parents and grandmother. So it is, blood curdling to think of, a thing happening to a child. And how can a child, a 12-year-old child, be said to be called a terrorist? Can he be executed? So after this judgment, there have been at least out of maybe 3 incidents of death. But prior to this, 1,530 people. Then we have this Puttaswamy's judgment. Right to privacy, is it a fundamental right? Yes, it dealt with the question whether privacy is a constitutionally protected value under the Indian Constitution. It held that right to life primarily emerges from the guarantee of life and personal liberty in Article 21 of the Constitution. By holding right to privacy as a fundamental right, it overruled its earlier judgments in Kharak Singh and MP Sharma's case. So, and then the Supreme Court also relied on Puttaswamy's case to declare 377 of the IPC unconstitutional in Navtej Singh Johar. And they also decriminalized adultery in Joseph Shine's case. And, in Shabarimala's case, they dealt with entry of women. But there again, Justice Indu Malhotra, I go with her judgment, because I feel here this youth, Young Lawyers Association, who are my colleagues and friends, they are all North Indians. They had no knowledge about Ayyappa, but they felt that they stood up for the other women of the country, and they said, why should we be discriminated on the ground that we cannot have darshan of this? So faith has no logic, but still the 4 judges held, yes, there is a right of equality, so these women should be allowed to enter the temple and worship the God. So, and then you have Lily Thomas versus Union of India. So Lily Thomas, she challenged that she challenged this criminals. Should not criminals be kept away from politics? Should not MPs and MLAs be disqualified on the date of a criminal conviction? So the court said, yes, it was free. It was aimed at freeing the political setup from criminal elements. So they upheld the validity of Section 4 of the Section 8, subsection 4 of Section 8 of the Representation of People's Act as ultra vires the Constitution. Then you have this famous case of Vishaka guidelines that was in 1997, how an incident involving sexual harassment at the workplace should be dealt by an employer. But Vishaka judgment came in 1997, but the guidelines, the act, the Prevention of Sexual Harassment Act came into force in 2013. So although the law has been laid down, the executive, the parliament, they take its own time to frame these laws. But nevertheless, the law has been framed. It has come handy to many, many people. All these women, the Me Too movement and things like that. So people have started opening up and speaking. So these are the things, how the Supreme Court has in fact, in the Guruvayuram Devasam Board judgment, they facilitated the relaxation of procedural rules. They they made it a little relaxed. They gave terms as to who can approach the court, who can knock the doors. So it was not strictly procedural or anything like that. Then in Vineet Narayan's case of 1997, they said, should not the CBI be insulated from political or from executive interference? Yes, the Supreme Court said, yes, they laid out several steps to curb the influence of the functioning of the CBI. And it laid out similar guidance for Enforcement Directorate. So these are the guidelines following. Actually, this Vineet Narayan's case is also of 97, and there they followed Vishaka guidelines when insulating the CBI from political interference. So this is how the Supreme Court has risen to the occasion. High courts have risen to the occasion and laid down laws, have been saviors to many, many, many litigants in this country, brought about a lot of difference in the lives and quality of our citizens. Thank you.
Yes, ma'am. It was a really very fantastic session. In the starting, you have elaborated about the Montesquieu of the separation of the powers, and thereafter you have incorporated the various judgments of the Supreme Court, like Menka Gandhi, Olga Telles, then all the latest judgment you have incorporated, which I am also refreshed today, because since long I have also not read these all judgments, so it is a very good part. Madam, I have one question, and my 2-3 questions from the students are there. Madam, in Delhi, still the women are being harassed by various people, and the police is not taking a correct action at the same point of time. So my question is, madam, as you are the leader from the women's cell at the Supreme Court, and ma'am, it is my humble submission, madam, what the executive and what legislatures should look after in this, and even though the judiciary also, because we have Section 57 that he has to produce before the police station in 24 hours. But still I found that when I go to the police stations and I read the story of the litigants, I found that still there are certain cases where they are not producing in 24 hours. And even though, because in CRPC it is written that when there is a delay time, it should be excluded. But still, madam, there should, this is my perception, that there should be a need from the Supreme Court and from the judiciary that these types of immediate action is not taken place, ma'am. So what you tell about this, ma'am?
Professor, in fact, I must tell you, if you see the criminal amendment, the amendment in the POCSO Act of
Yes, ma'am.
2019, which said brought death to these child rapists. Let me tell you, I've been part of that legislation, because the Supreme Court Women Lawyers Association, we moved the Supreme Court because I felt very bad when I read about a newspaper clipping of a 28-day-old baby who was raped. So I asked myself this question. As a mother, I was moved. Why? Because a 28-day-old baby is not safe in this country. So what should be done? So the law needs to be a little harsher, and stringent punishments should be recommended, So I moved the court and said, we asked for harsher punishments. We wanted chemical castration and death. So Supreme Court said, which is not in our domain, but we still recommend these suggestions to the parliament to bring in this law. It was done in 2016, and in 2019 we saw the fruit of our efforts. So here also we have Lalita Kumari versus State of UP, where the Supreme Court has laid down the procedures for arrest and all kinds of procedures relating to bail and things like that, but still it's not being implemented. Why? Because the executive should stand up. They should not, like, if I just told you, in 1977 policy decisions were never reviewed by the Supreme Court, but now in 2000, late 1990s, they are doing it. So today, if any tender is passed or any kind of allocation is given, the babu who does this work, he has to be very, very cautious of the fact that his decision can be hauled up in Supreme Court. It can be reviewed. So these are the things they are very cautious of. So in fact, it has to be implemented. The police have to be trained. In fact, the police are there, but none of them have the basic knowledge of how the procedure has to be followed in IPC. So they must be given, these kind of and make them aware of the rights of the citizens. They just take the dhanda and they beat. So that should not be, that should be done away with. So I would recommend, there are laws in existence, but even the police need to be made aware of how they can protect the citizens. They are there to protect the citizens, but they are in fact turning the harassers. Everyone thinks 10 times before he goes to the police station. Why? Because of there is so much of corruption, and then there is so much of bad blood. I mean, can they stand up to the pressures of the police? No. So these people also need to be given classes and coaching.
Yes, ma'am. Very fantastic answer by ma'am. Madam, one student of my PhD student, he is asking that judicial activism is really it is interconnected with the judicial review. There is one judgment of IR Colo judgment that where the Supreme Court has laid down about the judicial review. Madam, the question is by the student that how you can interpret that still there are certain cases where the Supreme Court taking the cases after filing the judicial review, but sometimes it is they are not satisfied with the judgment of the Supreme Court. So what can be the next step when, let us suppose, the smaller bench has it is upheld the High Court judgment, and after that it is going to the larger bench. So, ma'am, what is your opinion about this, ma'am? So suppose I want to challenge a judicial review which is already with the larger bench, so where I can go to challenge that judgment?
See, Coelho's judgment was one of the landmark judgments on the interpretation of the doctrine of basic structure as laid down in Keshwananda's Bharati's case. So it also held that the 9 schedule items are not immune to a judicial review, as it is part of the Constitution. So once you're not happy with the 3 judges, you can file a case asking them to review it by a larger bench, citing case laws where two benches of the same court have taken different views. So that is how it is referred to, So, and whatever is reviewed and referred to, see, Supreme Court does not go only by the laws and things like that. They take into analysis all the data which is before them. They take into account the laws, then they deliberate, and then they come out with their judgment. So that is how laws are laid down. So that has to be accepted.
Madam, one more student of LLM, she's asking that, like in Sunil Batra case, there is a brutality to this Sunil Batra, but still in the jails, there are certain issues are there. Still, the jails are not performing. So, what the judiciary should interpret in these types of aspect for these prisoners, ma'am?
See, at the most, even Sunil Batra was a prisoner who was housed in Tihar jail. He was a prisoner himself. He wrote to the Supreme Court and he cited the plight of the prisoners. He said this is it. That's how Kiran Bedi was brought in as the IG of Tihar jails. So she brought a lot of changes. She was one of the best women, and she went on to win the Raman Magsaysay Award. So there are loopholes. There are loopholes everywhere, But who is there? See, Supreme Court can only do. It is for the executive, right, to manage and bring. Bring about changes. For everything, you can't keep on moving Supreme Court. What should it monitor all these things, or should it render justice? See, it has done. Now it is within the domain of the executive to take charge and be strict. They should bring in officers who control and follow the system according to the rule book. See, there are so many things happening across the country, Professor, but Supreme Court has done a lot to bring changes. What Sunil Batra's time is, it is not now, it's undergone a 360-degree change. It's gone a 360-degree, drastic change. So, yes, even now there are certain things, but it has to be brought to the notice of the IG, and they have to make certain changes, and they have to be strict in enforcing the law.
Yes, ma'am. Very well answer, ma'am. Now I will say Akhil Sayyed, sir. Akhil, sir, are you there? Hello? Akhil, sir.
1 hour. Actually, it's a great opportunity to listen such a intelligent and with full of experience, because what we academicians do have our limitation that we read from the books, but the learned advocate from the Supreme Court, and that too such a distinguished personality, when speaks, she seeks from the experience, and that definitely helps us not only to the students but to the professors also. So thank you, Rajesh, for inviting ma'am, and I once again, ma'am, invite you to be here on the campus. Thank you very much.
Thank you, sir. Sir, apart from speaking from experience, whatever I've done in life or whatever I do for others, I do it out of passion. So yes. I stand up for all those women who don't have access to justice or who are victims of sexual abuse or domestic abuse. And so we do. Our Supreme Court Women Lawyers Association, in fact, yesterday itself, we moved a IA in one of the cases seeking, gender parity and equal representation on the bench of the higher judiciary. So that matter is listed. So let us see how many good women judges this country will now see with this verdict.
No, we see your good self to be elevated as a lordship there in the Supreme Court of India.
Inshallah.
Inshallah. Yeah. Thank you, ma'am. Thank you very much, ma'am.
Thank you, ma'am. Thanks a lot for your kindness on us, and we are thankful for this. I'm also thankful to Jiten Kobani sir for the very good live coverage. So we are ending this session, ma'am. Thank you, ma'am. Thanks.
Thank you.